931-393, 766-9393. Stan will be glad to take your questions, and I'll be able to patch you right in. So.
And we are good, and I gave you a plug on LX, so maybe we'll get some calls going on.
Good deal.
I was just about to give the number, but thank you for.
Yes, indeed.
Sometimes I need preempting.
Yes, indeed. Thank you, by the way, for the technical assistance.
Yes.
Well, you know, when you're when you have it, you have it.
You
I'm
have it,
sorry,
you have
Jeff. One day I might get you up to speed.
Okay, very good.
Thank you, Miss Charlotte. You got a problem when the boss comes in and fixes it themselves.
Yeah, that's right. Something was wrong there that I couldn't figure out, so I sent her a text message.
You know, technology is wonderful
Yes,
in a
it
lot
is.
of ways.
Yeah.
But it can be detrimental in some others. I mean, and it's not just keeping up with it in general.
Yes.
I know, when I'm working on a car, like let's say my wife comes home and says, hey, the car's doing this or doing that. And I look at it and say, okay, I don't know, this needs changed or something. It's like, all right, if you go to YouTube and Google it, chances are probably 90% you're going to find somebody talks exactly how to do that.
Right.
So it's really great for stuff like that. Now, it's not so great for some of the stuff I do, because if you go and Google some of this estate planning stuff, especially stuff related with long-term care and TennCare, you get a million opinions, but they are really just that. There are a lot of I can't find any that are founded in too much fact or law.
Well, when it comes to doing something like this, your personal circumstances are your personal circumstances.
Absolutely.
And they need to be addressed individually, not blanket.
One size does not fit all.
Right, exactly.
But, one thing I like to go over, I do this personally for my own, just for the benefit of my business and my ability to serve the people that come and want to do estate planning. But I like to share it sometimes on these radio stations. And that is, I review certain court cases that come out of the courts. Now, I certainly review the ones that come out of Tennessee because, we are Tennessee. But we also review courts cases in other states, especially the other states. There's about 22 other states that have very similar trust and will laws, probate laws as we do. And so when they're similar, it's persuasive authority is what it's called. When it comes out of Tennessee, it's what they call mandatory authority. So I keep up with that. And the reason I like to talk about them, and I don't get into it real deep. It's not intended to be a law lecture by any means. But the bottom line is, if we see what the courts are going to uphold, then we know those are things we want to do. And if we see things they're going to deny or shoot down or disagree with and not enforce, then those are things we don't want to do. I used to do a lot of that in criminal law. And, so you want to, it's as simple as you want to do what the winners do and not do it, and you can learn what not to do because of the things that the courts won't uphold. And so I bring it up from time to time because we can learn from these things. Now, the one I want to bring up now just came out. Let's see, it's July the 14th is when it was actually issued, so it's hot off the presses. And it's really not going to be about what we have been talking about the last couple of weeks or what I'm going to talk about the rest of today, but it's part of estate planning that I think I talked about when I was talking about fundamental planning. Yes. And that is, one of my pet peeves about estate planning is this concept of having a power of attorney. And I think people misunderstand power of attorney. One thing, it does not survive death. A lot of folks come in and say, well, Dad passed away and, I've been writing checks on his account as his power of attorney. And, technically that power expires at death. And after death, you have a different power to act on somebody's behalf, but it's not power of attorney. And we are a uniform power of attorney code state. And so one of the pet peeves I have is when I sit down and I do trust plans for people, and some of them, some percentage of people say, we've already got power of attorney. Mm-hmm. We did those, a couple of years ago. Here they are. I will look at them, and I often find them lacking. Now, my goal is not to find them lacking. My goal is this. If a power of attorney doesn't say you can do certain things, then you can't do it. Okay, let me expound upon that.
Okay.
If you go to the Power of Attorney Act, or Uniform General Power of Attorney Act, they list several powers, 20-some powers. And those are general powers. And it says you have these powers, but it's not limited to those. Now, it also lists what it calls enhanced powers. Okay. Now, the enhanced powers are a little different. Enhanced powers are, what we call a non-delegable right. And the only way you can have somebody do an enhanced power for you is if that power is expressed in the power of attorney document. Express means actually written there, right? So, and one of those is to be able to deal with a trust. Mm-hmm. So if you're doing a trust plan, and you're naming your kids as the successor trustees on it or whatever they're fiduciaries in your plan, we want to make sure the kids have the ability to deal with the trust that you're setting up. And if your power of attorney doesn't say they have the ability to deal with the trust, then they haven't got it, because that's one of the enhanced powers.
Okay.
Now,
That's interesting.
and so, so a lot of times I'll look at a power of attorney, and it'll be very brief, and it'll have language like this. This power of attorney incorporates by reference all the powers in the code. Okay? And then it'll have other language that says, my agent can do anything and everything that I can do. Now that sounds all-inclusive, does it not?
It does sound
I mean, if my agent can do anything and everything, it sounds like, well, they can do anything and they can do everything. Well, it does not include those enhanced powers. The enhanced powers under law says these are non-delegable rights, and in order for your agent to perform them, the power must be expressed in the document. So anything and everything doesn't express the ability to deal with trust. Now, when I say deal with trust, I'm talking about possibly making a trust for someone. Mm-hmm. One of the general powers is it does deal with trust. It says a general power under the code says an agent can, for an existing trust, one that you've already set up, you the principal, right? One that's already been set up, you can fund it and add property to it and stuff like that. Now, it does not say you can create one. That is an enhanced power to say you actually can make a power for someone.
Yes.
I mean, make the trust for them. You make it, you sign it. I mean, the person, say, incapacitated, that's when mostly power of attorney applies, is during incapacity. And so, in other words, let's just say, like in this court case I'm going to talk about for just a second, you have power of attorney for somebody, and they're incapacitated, and you want to do what we're talking about here last couple of weeks and next couple of weeks about protecting their wealth from long-term care. Mm-hmm. And you think, I need to do one of those asset protection trusts I hear estate plans Stan talk about, or something along those lines that will protect your property from that. Well, if the person is incapacitated, they certainly cannot sign it, and they can't do it because they're not competent. But can you just make one for them? And the answer is, it depends on if that power is in your power of attorney or not. If it's not there, you cannot, and the courts will not enforce that. If it's there, they will. And the powers you put in a power of attorney is up to you. It's like painting a canvas with a pretty wide brush. You can put in a lot of them, all of them. You can put in some of them. You can have a limited power of attorney. We've done that. We're going on vacation for a few months. We want a limited power of attorney for these people to be able to make decisions about our child as far as school goes, or stuff like. You can be limited or you can be general. Now,
Sure.
So that's the backdrop behind this. It has to say so in the power of attorney. Some of these old school 2-page power of attorneys that say, hey, my agent can do whatever I can do. They just don't fly in this estate planning world. So anyway, a case came out. I don't know if you want to hear the style of it or not, but the style is called Kim Williams versus the Lewis Preservation Trust. It came out of Ray County. And I guess it was just issued July the 14th, so 2 weeks ago.
Wow.
Right? And hit the presses. Now, here's the Reader's Digest version of the facts. These folks, mom and dad, had a revocable living trust. And they had 3 children. One of them was named David, one of them was named Kim, and it doesn't matter what the other one was. But they had this revocable living trust. The father passed away, and the wife was still living, but she had become incapacitated. And she was in a memory unit, and she was institutionalized, and so she was deemed incompetent. So the son, David, was named as power of attorney, was acting as such. So he decided to create an irrevocable trust, and in the case it talks about that his intention, because this case went to trial. We have the transcript to read whatever all the witnesses said. Mm-hmm. His intention of making the irrevocable trust was to set up a trust to protect their funds from long-term care, because this couple had a rental property business. Okay, so they had some assets in real property, and it was income producing, and so it was pretty valuable stuff, and they wanted to pass it on, and they didn't want it to be lost or consumed to the long-term care.
Yes.
So just what we talk about the last several weeks, and this next couple of weeks, about this preserving assets for long-term care, he wanted to make a trust and move these assets into it. Now, if you remember last week, I talked about that and said when you move assets into an asset protection trust, you immediately make them non-countable. Okay, so
yes.
You can put thousands and hundreds of thousands and even millions of dollars into a trust in property, and the moment you do that, it's non-countable. So whenever you file your 10-K application, they say, how about listing your countable assets? It's like, I'll be glad to. And it's not going to be any of these because they are non-countable.
Yes.
So that, and we'll talk a little bit more about that again today. But so that's exactly why. That is exactly the purpose why David decided to make another trust, an irrevocable trust. Now, I'm reading this, okay, and I'll just share my mental viewpoint as I'm reading this case, okay?
Okay.
And I read that and I'm thinking, okay, David may or may not have a problem. As I read further, what I'm looking for is what does his power of attorney say? And so David's making a new trust for an incapacitated principal.
Yes.
I'm thinking, okay, she can't sign anything, she can't direct anything, she has lost her cognitive ability to make decisions legally.
Yes.
So I'm thinking, okay, David might have a problem. I think this case is going to fall or stand on the language and the power of attorney. I could just see it coming. So I read further, and what happened was he did this. He took the assets out of the revocable trust and poured them into the irrevocable trust, and for these purposes. Now, somewhere after a while, Mom passed away. And after she passed away, and it comes time to start dividing up the property, the daughter, Kim, who's on the style of the case as the challenger, decided to challenge the case. And her sole challenge, well, there's a few other little things, but the main thing for our purposes, she challenged his ability to create a trust for Mom in her mental state of deterioration, okay?
Okay.
And again, I'm thinking, okay, here it comes. Can he or can't he? Okay. Now, the court says, okay, we're going to determine this factor. And then I read the paragraph where the court says, the crux of this case will begin and end with our reading and analysis of the language in the power of attorney. Okay.
Wow.
So I'm thinking, okay, here we go. So they pull up the power of attorney and they start looking through it. And I could read it to you, but I'll give you the Reader's Digest version. They find the clause that says, my agent can establish trust for me, whether they're revocable or irrevocable, and fund them, and all the good language that needs to be there. And there's only one qualifier. The qualifier says, as long as it is in my best interest. Okay, so you're an incapacitated person, and you're saying, you can do this for me, but it's got to be in my best interest. Meaning you can't put it onto a trust and then say, okay, it all comes to me. You know what I mean? It's got to be in my best interest. So the court analyzed that, and they said, look, this is a right that has to be in the document, and it is. They said she gave him the power to establish trust. Establish means create.
Yes.
And he said, we see only one limitation on this power, and that is it has to be in her best interest. And here's another, this is like a bonus to this case that the case wasn't even about. But the Tennessee Court of Appeals said, and we consider taking your assets and putting them into an irrevocable trust for the purposes of preserving them and protecting them from the high cost of long-term care in her best interest. So here we got the Court of Appeals of Tennessee putting the rubber stamp on what I'm talking about, what I do. They're saying, well, this is definitely in her best interest to do this for her.
Yes.
So anyway, the bottom line is they said, we're going to, the challenge is, you don't win the challenge. The challenge is he has the power. We're going to uphold he has the power because it was in the document. So
wow.
Sometimes you got to read between the lines but they didn't come out and say it. But what they're saying is, if it wasn't there, we would not have upheld it. But
wow.
Because our analysis begins with a reading of the document. So if you got a power of attorney that's already done, and if you hear this and you say, I'm going to go look at that, and you don't see a bunch of stuff in there, for one thing, don't panic. It's an easy document to change. As long as you're not incompetent. Now, once you're incompetent, you can't change it.
Right.
But if you got one and you don't think or you want me to take a look at it, and I don't recommend doing a new one unless I think there's an issue.
Yes.
And so don't panic if yours is one that just says, I incorporate by reference the terms in the code, because that's only the general powers that it lists. It does not include these enhanced powers. So if it's no big deal. It's a simple fix. When it's not a simple fix is once we cross this line of incapacity. Now we got a problem. So anyway, that was, I was very happy to read that case because it just kind of puts the stamp of approval on a lot of the stuff we do. There was also some talking here about what the no contest clause. I think you may have heard me talk about that when we were talking about foundational planning, that if you put a no contest clause in a will, okay, which people ask me to do, and I tell them,
what does that mean?
A no contest clause means if you challenge this because of you're not happy with what you get. Mm-hmm. You don't get anything. The default is your punishment for challenging this after the person passed away, because they're not here to defend their document.
Okay.
It's called an interim clause, is the Latin for it. And we call it a no contest clause. And it says if you challenge this, you don't get anything. You take, basically the language is you take as if you predeceased. Okay. Now, I talked probably a month or so ago. We talked about wills. If you put a no contest clause in a will, it has no force and effect. The Uniform Probate Code directs the court to give that no weight. It is not enforceable.
Right.
Although people ask me to do it all the time, and I tell them I'll put it in, but it's a waste of paper and a waste of ink.
Interesting.
It might be a deterrent, but if push comes to shove, it's not going to carry the day, right? However, the legislature said if you put a no contest clause in a trust, we will uphold that 100%. Because if you remember, I used the language from the code that says the legislature considers the intent of the trustor, the maker of the trust, paramount, and will not disturb their intention,
Right.
absent compelling evidence. And so this case talked about that very thing, because one of the things was because she challenged this, then they counter-challenged the daughter was to challenge this and said, since she did this, we want to enforce the no contest clause and have her take nothing. And they go into great length, but I'll give you the Reader's Digest version of that too. If you challenge it because you don't like your share, that's what you get punished for. Okay.
Yes.
If you challenge it because you think the trustee is abusing their fiduciary duty, that does not trigger it. So let's just say, let's say I got 3 kids, and for simplicity in my trust, I say each get a third of everything,
Yes.
whatever that is.
Yes.
And one of my kids says, and one of them is the trustee, the successor trustee.
Yes.
And they're at odds with each other. They're on the outs. And,
It happens.
And one says to the other, says, you know what? You haven't called Dad for 10 years. You haven't even sent him a Christmas card. I don't think you deserve that third. I'm gonna give you a fifth. Okay, I'm going to give the rest of it to myself and the other sibling, right? Well, she's entitled to, the person that they're doing this to is entitled to a third according to my intention, correct?
Yes.
So let's say they launch a challenge. They're not challenging that the third's not enough.
Yes.
What their challenge is, I'm entitled to a third, and he's going rogue and breaching his fiduciary duty and not giving it to me. He's bound to the terms and conditions of that trust.
Yes.
And and they upheld that they shot that down and said, look, she has always maintained that he did not have the authority to make the irrevocable trust under the power of attorney.
Yes.
She is not challenging what she gets under either trust.
Right.
Just that he couldn't do that. So we are not going to trigger the interim clause, because the interim clause is designed for somebody who wants to challenge what they're actually getting.
That's very interesting.
It is. Yeah.
Very interesting.
And so what I've been saying, so when I talk about stuff and I say, hey, this no contest clause is not enforceable in a will.
Yeah.
Some people say, well, that's just your opinion. Well, I don't give opinion. I do, but I give opinion based in fact and based on the law. And the only reason I bring this up is to say that I don't make this stuff up. I do what the courts say they'll enforce. So if anything of mine goes to these courts, I feel like I got a head start because I know what they're going to say when they get it.
You have a library of precedent.
Yeah, precedence means once settled, always settled.
Yes.
So I can go in there and say, look, in this case you said this, and in this case you said this, and in this recent case of the Lewis Preservation Trust, you said this. Now, here's my facts, and I expect you to say the same thing because they're right in line with what you say. That's how you win a case in one appeal.
Exactly.
That's exactly how you win it. And they won't listen to that. They're not going to branch out and say, yeah, we've been doing this for 40 years, but we're not going to do it. It's not willy-nilly at all. Because every time you read one of these court cases, the court will make a statement. Then following it is a half a paragraph of citations of where they've made that statement before. They do not make, they don't break new ground. They're very reluctant to. If they have to break new ground, they will. It's called a question of first impression. If they have to, they will. I actually have a appeal on a 10-care case that I think falls in the category of a question of first impression because we have appealed it like 4 times now. And now the state, and then we finally won, and now the state has appealed it. 10-care has appealed it. So I think it's something that neither side, nor the administrative court that's dealing with this, feels like they have direction on this issue.
Yes.
So we need a higher court to step in and give the direction based on the law. But that's why I feel very comfortable when these cases come out, and that's why I want to talk about them. If the courts are going to uphold, if the courts says this is mandatory persuasive material, if our courts say it is in a person's best interest for you to make an irrevocable trust for them to protect their assets, there's more to that. Then it's certainly, if it's a good idea for you to do that for an incompetent person, then it's certainly a good idea for you to do that for yourself. And you're not in what I talk about. Come see me or somebody like me and say, hey, I want to protect my assets. And, is it okay if we put it in one of these irrevocable trusts and stuff? What the court says that is in the best interest of a person to do that. So in a backdoor sort of way, they're endorsing this process of estate planning as being a good thing, an acceptable thing to do.
Yeah.
And someday I'll talk about some of the cases that actually talk about this trust we do, the Asset Protection Trust. And there's been quite a few cases where they say this is a perfectly viable way of a vehicle for estate planning to preserve unlimited amount of property.
Yeah.
They acknowledge. You just have to do what it needs to be done, and that is put it in there. Got to stay out of the nursing home for 5 years. You can't have this access to principal that we talk about. Remember, you can have control. All these things that the trust does, they have upheld. And I've got 1,000 hours, probably every bit of 1,000 hours in perfecting this trust in these things. And if something would have come out in a case like this,
Yes.
that I wasn't doing, I would change everything I did from this moment forward to support what they will support. So it is, and of course that doesn't happen very much because these things have been around for a while. There's not a whole lot of new stuff comes out of them, and that's a good thing. They're not changing all the time.
Yeah.
So anyway, I think it's helpful to go over these things, and sometimes the reason I even do it on the radio is because I want you to know the stuff I talk about and the stuff I recommend doing. It's just not my chapter and verse. It's not First Pierchoski chapter 14, saying this is what we need to do, right? It is. There's a lot behind what the recommendation is. It's not mine. I mean, I can do it and I understand it, but I'm not the one that made the decision. I didn't make the law. I didn't interpret how the law works. What we do is we take advantage of these things and apply them to our circumstances. And if there is a way that the law, the Medicaid, the Federal Medicaid Act, the TennCare Act, which adopted the Medicaid Act, and the courts that interpret those things, if there is a way to take the assets you have and protect them from the exorbitantly high cost of long-term care, why wouldn't we do that?
Yeah. Why would you not?
I mean,
do
why
that?
wouldn't you? Okay,
Yeah, absolutely.
so feel comfortable and confident. I mean, I just don't make it up and say let's hope for the best. We definitely want to do this.
It's about protecting the assets, one's assets, but it's also about ensuring that what happens to those assets happens according to what your will is.
Exactly your intention.
Your
You
intention.
the maker. Because if that's the case, you're not here. You can't defend what you've done, and and it's difficult. You don't bring people in to say, "Well, Dad told me this." He said he wanted to leave it all to us a third each, but one day he got me on the side and he said, "I want you to have 3/4 of it." That just leaves yourself wide open to abuse. We have a thing called the dead man statute, which is the admissibility of evidence after somebody has passed away about what
Right.
what a deceased person said.
Right.
It's a lot of scrutiny, and it should be. So, anyway, I think that's useful and helpful to people. So, when the courts are behind what we do, it just enforces my ability and my confidence in what we do. It's one time something came up out of another state, and I knew it was wrong. But it sort of talked about a mindset, and I thought, there's a mindset here. And so I modified my trust ever so slightly to kind of just, even though I know it was wrong, and even though I'd never seen it happen in Tennessee, I just thought, this might be an easy iceberg to steer around, just in case it ever does end up in front of us,
Sure.
And so I modified what I do just a little bit, and it wasn't a big factor in the thing, but I just thought, it's just the fact that it came up in a state or two. Tells me they're thinking about that. And of course, they were unsuccessful with it, so they were wrong. But anyway, so I learn from these. I'm constantly trying to learn from these. I'm constantly trying to make sure everything we do is, the best it can be. So, all right. So with all that, I'm going to transition, try to pick up where we left off last week, and with this show, with questions and call-ins and that
Would
stuff.
you like a question?
I get sometimes I have something. Okay, where did I leave off last week?
Yeah.
But as I don't like to shift gears that fast. So yeah, if you have a question, that would be a nice way.
Well,
to...
I had a question, and it stems from the story that you told about the case there that just came up. He created this trust and moved the assets into the trust.
Correct.
If you have a trust already, and let's say you acquire something or establish a new account somewhere, it doesn't automatically go to that trust. You have to what's the process of getting an asset into a trust?
Okay. Well, we call that funding the trust.
Funding the trust.
And that happens, let's say you don't have a trust at all and you just decide to create one. So we create one today. We sign the documents, you make your trust. And if you're in my office, I have a big whiteboard and I'll draw a box and I'll say, here's your trust. And we're going to call it the Hood Living Trust. Okay. I say, we've made your box, but it's empty. There's nothing in it.
Right.
And it has to be empty because we just now made it, right?
Okay.
So now we want to fund it. Means we want to move the property into it.
Okay.
So if you want to move the property into it, once it's in the trust, now the trust protects it. But the trust can only protect what is in it.
Okay.
Now, every time I say in the trust, that is kind of a street vernacular kind of thing. We all say it, attorneys, non-attorneys, we all use that term, but you need to understand what that term means in the trust. A trust is a legal fiction. It can't really hold property. And it's not like there's, when you say in the trust, it almost sounds like there's a place in the back of the building where we kind of pile up stuff.
Right.
But, so it's the way we put something in the trust is we take the piece of property and we vest it with the trustee. Okay? That's what in the trust means. So here's what that looks like. And I'll use a deed because I know you're in the real estate business and this will answer your question even better for you because you see this kind of thing. So you have a deed and let's just say I pulled the deed to your house and it's in Jeff Hood's name. Okay. Just Jeff Hood. No insult to your wife. I'm just using it for simplicity.
Yeah,
right?
absolutely.
Okay.
Sure.
So it's in Jeff Hood's name, Jeff Hood. And so you say, I've got this trust, the Hood Living Trust. I want to move my house into it. So we write a new deed. Now the new deed, at the top of where it says the different players, at the top of the deed says the grantor. That's going to be you, Jeff Hood. You're going to be conveying this property. And it typically will be a quitclaim deed. And then the new grantee, the new owner, so to speak, is going to be Jeff Hood, trustee of the Hood Living Trust.
Okay.
Now, we have just moved that property from outside that box to inside the box because now it's in the trust because it's vested with the trustee, which is you. Or if it's somebody else, it would be John Doe, trustee of the Jeff Hood Trust. Whoever. If it's vested with the trustee, it's in the trust. That's what that means. Now, you had mentioned something. If you have a trust and you acquire some property, does it automatically go into the trust?
Yes.
Now, it can. And here's an example of that. Let's say you did that. You put your property into the trust, right?
Okay.
That's your house.
Okay.
You have your trust. If 5 years later, sometime later, the 5 acres next to you opens up for sale and it's a great price. And you think, you know what? If I buy that, I can eliminate neighbor problems. Nobody's going to buy it and build right next to me, right? So
Sure.
I'm going to buy that lot. So you buy it. Well, what you can do is at the closing, you say, oh, listen, at the closing, make the deed out to Jeff Hood, trustee of the Hood Living Trust. And that way, when you obtain ownership, it's in the trust from the get-go.
Okay.
Now, if you run into a title insurance company that says, well, we're not going to do that, or for some reason, and they just deed it to you, then you just have to, it's a two-step process.
Right.
You say, okay, you deed it to me on Monday, Tuesday I'm going to deed it to the trustee of my trust and get it in there. So,
But the trust itself, as far as the document, the trust itself, doesn't have to reference your properties.
No. Well, the only time we ever reference the properties is suppose you say in your descent and distribution, okay, you have 3 children?
Yes.
So you're going to say, okay, I'm going to leave, I got 3 pieces of property, and I'm going to leave this piece of property to this child, this piece to this.
Yes.
Now, in that distribution, we would make reference to the properties that are in the trust because we're referencing where they're going. But you don't have to. Some people say, you know what, I'm going to be simple. I got 3 kids. I just want them each to have a third of everything. Whatever real estate's in there, whether it's 1 piece of property, or 3, they get a third of each. Now, in that case, they wouldn't each get a piece of property. They would each get a third of those 3 properties, right? So in that case, it wouldn't necessarily be necessary to reference the individual properties. A trust kind of doesn't know what's in it.
Yes.
And it doesn't need to know what's in it. It needs to know if it's distributing something specific to somebody.
Okay.
So if you say, I'm going to leave my my old truck that I've been restoring for years and it's my prize and joy, I'm going to leave it to my oldest son. Well, the trust can only give that to the oldest son if it's in the trust. Okay. That kind of thing, that property. So that's how we put property in the trust.
Okay. So beyond real estate, if you've got you've established a 401k plan or your retirement with an investment company, that documentation has to reference that it's owned by the trust of trustees.
That's right. That's one way to do it. Some things are just beneficiary driven.
Okay.
Meaning you don't change the ownership to the trust. Let's take life insurance. That's a good example.
Okay.
Life insurance, you don't really own it. I mean, you can if it's whole life or something like that, but it's beneficiary driven. So instead of putting the policy in the name of the trust, we put the beneficiary as the trust. And now the $300,000 death benefit goes to the trust because you don't own the $300,000. It's a death benefit that happens on your death.
Okay.
So a beneficiary-driven instrument, we still do put in the trust. We just change the beneficiary trust. So the big difference is, if you go to the bank and put your bank account in, they change the ownership from you to you, the trustee. So it goes into the trust that day. If it's a beneficiary-driven instrument, it goes into the trust. It just doesn't go there till death. But it's in the trust when it needs to be. Okay. And it can be distributed that way. So, and a beneficiary-driven instrument is, in fact, a probate avoidance technique, because it doesn't pass through the probate court. It passes by beneficiary or by contract.
Yes.
A lot of times, and that's exactly what they'll do, because here's the way we solve a problem. Let's say you have a child, I don't know, that's got a problem, and you want to protect that problem, his inheritance from that problem. I often use, say, have a drug or alcohol problem, but let's just say you got a creditor problem. You got a son who's an entrepreneur, and he's got creditor issues, and you want to protect your inheritance to him from his creditors. You can do that.
Okay.
But let's say he's the beneficiary on a big term life insurance policy, and $500,000. And you think, gee. So I call New York Life, and I say, hey, listen, my son's got these creditor problems. So at my death, I don't want you to give it all to him at once, because it'll be, all available to creditors. They can come and seize it. I want to, before you get done with your sentence, they're going to say, listen, hey, sorry about your kid, but we got an obligation to pay, and that's what we're going to do. If it's a qualified death, we're going to cut a check, okay? I mean, I get it, and I sympathize, but there's nothing we can do but just pay the beneficiary, right?
Yes.
That's their job. That's what the contract
That's what
says.
they do.
If it's a qualified death, meaning it's not a suicide or something,
Right.
we'll pay to your son, the beneficiary. So the way we fix that problem is we say, okay, I'm going to change the beneficiary from my son to my trust. And in my trust, I'm going to say he gets a little bit over a year, so he can't blow it, or I'm going to give it to him in trust itself and protect it from his creditors.
Mm-hmm.
I can implement controls and terms and conditions in the trust, but the trust has to be distributing the property to do that.
Oh,
so
wow.
we make the beneficiary the trust and go there first. And now we say, okay, your son, here's your money, but now we're going to tie these strings to it because you got all these creditors and all these financial problems. So it's really a powerful, powerful tool. So there's a lot of things that got to be thought about how things talk to each other.
The more I listen to you, the more I figure out I got a lot to do.
Well, but the good news is it's all been done before. You know what I mean? What we need are your circumstances and figure out what fits that best.
Yeah.
Yeah. But you're right. I mean, and again, I'm not trying to teach folks how to do their own estate planning. It's just a little bit much. But I do think it's important you can know and understand what your options are and what you can do with it. I have people sometimes say, just what do you recommend, and just draw it up and I'll sign it. It's like, I don't do that. You need to be part of this decision-making process. So if you don't want to be, I'm sure you can find an attorney that'll just do it for you. I don't do that. I want you to be involved in it. I want you to sit down and we talk about your circumstances and say, look, here's what I recommend is the best fit for you, and here's why. Mm-hmm. And I think 99% of the people want to do it that way. They don't want to just say, you don't want to just turn it over to somebody to make decisions, because years later when it comes down to it, and if that doesn't work, now you've got little, if any, remedies at all at that time.
This is just a random thought I had, but are trusts recorded in any way, or how are they kept up with?
Well, I get that question a lot, so it's not too random. And the answer is no. There's no need to record it, and if you wanted to record it, I don't even know if they would. If you go to the Register of Deeds office where you record stuff, they have a miscellaneous book. And sometimes when they don't know what to do with something, it's not something normal that they have the deed book or the conservatorship book or the deed of trust book. They'll put it in the miscellaneous book just for the sake of recording it. If they record it at all, that's where they put it. There's absolutely no requirement whatsoever to do so because it's a private document.
Okay.
Now I guess you could, but you make it public knowledge.
So your recommendations on how to keep it safe would be what?
Well, I mean, when you do the trust with me, we put them in these books, because there's a lot of documents and a lot of things that go with it. We do them in duplicate because, scanned copies are not originals yet in Tennessee. So
Right.
a lot of our court pleadings we can do stuff like that with, but not across the board. So we do 2 identical originals. And I recommend to people, when you take these books home with you, you want to physically separate them at least. Put one in a gun safe or a paper safe if you got a document safe. Or some people have bank safes.
Yes.
Or sometimes people, their children are very involved in their estate plan, and the kids know exactly what's in there, right? If that's the case, it's a private document, but if they know what's in it and you want to leave one with one of your children, that's a good physical separation as well, because now they live here and you live there, and if something happens, you still have one that we have to recover from. So to keep, the keeping it safe, there is a certain amount of that. So I tell people, not only do you want to keep it safe, but you want to let your heirs know that you have a trust plan and where it is. So Jeff, you need to say, listen, I got a trust plan. It's under the bed. Okay. So, because, in the trust plan, these power of attorneys that I was talking about,
Yeah.
we have power of attorneys appointing who your agents are to act for you. And if they know where it is, then they can hit the ground running because their power resides in those documents. And so if they need to act for you, you're in a car wreck and you're in a coma and you're not making decisions, you're not making decisions for yourself in that position.
Yeah.
You need trusted people making them for you. So the kids know that, hey, I know he's got this trust plan. There's power of attorneys in there. He has named me as his agent. I know where it is. I go get it. I get the document. I go to whatever, the healthcare power of attorney versus in the financial one.
Right.
I go to the institution that needs me to make a decision. So when they say, under what authority are you making decisions for Jeff Hood, I'm going to say, this is my authority. And they'll recognize that immediately, and then you can do it. You can act. You don't want to hide it and be a scavenger hunt somewhere, or tell people you don't even they don't even know if you have it at all.
Right.
So I always tell people, if you have any kind of plan, will plan, trust plan, let your heirs know you have it and where it is. If it's in a safe deposit box, have something in place where they can get at it. That's if you don't do that, the bank doesn't let anybody into those things.
No.
I have written some pretty strong letters to the bank citing quotes and statutes and said, listen, this person is one of the people you can let in, and because they're worried about liability, right?
Sure.
And
Sure.
you are not liable if you let this person in. It has worked, but it's like pulling teeth sometimes.
I bet.
So sometimes you want to make that a little easier for folks. I had one gentleman tell me he had a child that lived here nearby, and a child that moved off to another state somewhere. So they're definitely geographically separated, and he wants them to work together. So he told the one child that lived nearby where the safe was to keep stuff in, but he told the other child that lived somewhere else what the combination was.
Right.
So they need each other to get anything done. I thought that reminded me of The Good, the Bad, and the Ugly. Remember that movie?
I do. I love that movie.
That was a movie where one knew the name on the tomb and the other one knew the cemetery that it was buried in.
Yeah.
But neither one could do it without the other.
That's right. It's
I
a
thought
good
that
way
was-
to good way to keep it up.
Well, he said, I want them to work together, and that's the way. That was my solution to that problem. So interesting. There's no need to record it. I don't know of anybody that did. Like I said, I think you would stump the register if you took it there, and if they did anything at all, they would probably have to record it in the miscellaneous book. But no need to do that. It is private.
Well, that was my thought was, okay, it's got to be kept safe somewhere.
Mm-hmm.
Yeah, and somebody needs to know where it is.
Now, I'll stray off a little out of my lane, like what we say in the beginning of this, stay in your lane. Let me stray out of my lane a little bit. And you're in a real estate business, and people take deeds and they record them.
That they
right?
do.
As a matter of fact, practically every Friday I'm here, when I leave here, I go to the registered officer with Lawrence County deeds that we've gotten over the week, and I record them because I'm here. There is absolutely, positively no requirement that you have to record a deed. It's a good idea, but you don't have to do it.
No.
You do not. I've come across folks that haven't recorded a deed and been for years and years. It's not necessary. You don't need to do it. Now, here's the thing. If you don't record it, let's say you buy a piece of property. Guy gives you the deed, sign, everything proper, right? Perfect deed, everything's valid. And here you hold the deed, and you're standing in the middle of your 50 acres, and you're just proud as punch, and, here's my place. I'm going to build, and I'm going to farm, and I'm going to do whatever I want to do with it. And you decide not to record it. Now, there's nothing wrong with that. Let's start off from that premise. The question is now, if you ever lose that document, that is the only indicia of your ownership that exists. Is that document you stand there holding your hand with that seller's signature on it. Because your signature's not on anywhere. You're the buyer. The seller is the one who signs it. Now, that's the only indicia of ownership you got.
Yep.
And if you lose it, you got a problem now. Okay? Or if somebody comes along, now this has nothing to do with this stuff you see on TV about title
Yes.
protection.
Yes.
Somebody could literally sell that property to someone else. And now there's a problem because now you got a bona fide buyer that didn't know anything. He was not put on notice that somebody owned that property.
Right.
As far as they know, they go to the public record, the original owner still owns it because there's no chain of title recorded showing it passed from him to you, the new buyer. So it is a good idea. I certainly recommend it. I mean, I don't like doing things if I don't have to do them, but I'm just saying there's a lot of advantage to doing it. But you absolutely don't have to do it.
It can cause a lot of confusion if something like that happens.
Oh yeah, Now, if 20, 30 years from now, if you decide to sell the property, I mean, no title insurance company is going to even deal with you until that gets cleaned up, and you can file it 30 years later. You can go record it.
Sure.
I've actually done that for folks. It can be cleaned up, and not that, when I say clean up, not that it's messy, but when you have other buyers down the road, want to make sure they're protected. That's the whole concept of what we call warranty deed. It ferrets out all the encumbrances and all the problems that are with the title.
Well, a title insurance company is not going to insure title without documented records being recorded.
Sure, and if they can't fix it, then they will carve out exceptions to their insurance.
Sure.
They're going to say, listen, if anything comes out of this, we're not covering it because we don't agree with
Exactly.
it. So, something like that seems to happen from time to time. I don't do much probate anymore. I tell people, people call me and say, would you do probate? Somebody passed away, and I say, or the girls say, I don't do probate. And they said, well, you talk about it all the time. And I hear you on the radio, and you talk about it all the time. I said, no, I talk about probate avoidance all the time.
Yes.
And I don't do it because it does consume my office for a year at a time. And so I have several attorneys that I refer out when I do
Sure.
that. But I will do some probate if it arises out of a trust plan we're doing for something. And here's something that's happened, often enough. Somebody will do a trust plan, and we'd say, okay, let's move your property into it. Okay, they say, I got these 3 pieces of property. So we do the deeds, and as we're doing the deed work, lo and behold, we find out one piece of property is still titled in their father's name, who
Yeah.
passed away 20 years ago.
Yeah.
And we look into it, it's like, okay, and then we find out that's where the people are living. So Dad passed away. He either didn't have much, or no probate was ever open because there was nothing really to pass. The property should have passed, but they didn't. They just kept living there,
It's happened.
And now 20 years later, we want to put it in the trust, and it's like, hey, guess what? I know you're putting this trust plan together, but you haven't got the authority to put this in the trust. It still is entitled to your deceased father. So I will clean that up. There's a couple of things we can do. A lot of times, if it's just that piece of property, it's 20 years later, you can do, depending on whether he had a will or not, you can do one of two things. If he did have a will, you can do a monument of title and transfer that into that person's.
Does there have to be a judgment to do that?
Monument of title is a probate proceeding, but it's very simple probate.
Okay.
There's no, or if there is no will, and you can show that that's the only heir, you can do an affidavit of heirship.
Okay.
But you can get it there. But once you get it there, you actually have to open up some version of probate to show that ownership now transferred from the deceased father to you.
Yeah.
Now we can put it in
But
the
it
trust.
can't be left in that state.
Well, it can be, but sooner or later, when a third-party buyer gets involved,
Right.
it becomes a problem and has to be fixed.
Right.
But I've seen it over 20 years. And people say, can you open a probate estate 20 years later? Yeah, you sure can. And actually, it's almost easy when you open it up 20 years later because there's no assets. I
Right.
mean, there's nothing. We have this piece of property we found that needs to be retitled, and that's the only thing we deal with. Well, in those cases, but you can sure do it. There's no requirement to open probate within a certain period of time.
Yeah. We're getting about 5 minutes
Yeah.
out. About 5 minutes out, and I know you've got a seminar tomorrow.
Yeah.
And so I want to make sure that everybody knows about that and more about how to contact you and that kind of thing.
Sure.
Because it's
We talked about it in the beginning of the hour, but let me go over it again. It's going to be, it's one of my seminars. We call it Wills, Trust in the Nursing Home. And that's kind of what we talk about. It's about an hour to an hour and 15-minute long presentation. And then there's a question and answer period. But it's going to be held at the Star Theater, right in the square over in Pulaski. The actual address is 105 North 1st Street. My office is right beside it. It's a great venue. We do that at 10 o'clock on Saturdays. So, we'll get started as close to 10 as I can because, we don't dilly-dally around. It's a fact-filled hour. But the folks that come are usually always, they're interested in this. They want to hear it. They're in other words, come, we're not going to have a meal and it's going to be willy-nilly and we're just going to shoot the breeze. I mean, we're going to hit the ground running and it's going to be nonstop for an hour, so a little more than an hour about facts and the options that are available. Then we open it up for questions. So the questions are just carte blanche. Anything you want to do, anything you want to talk about.
Right.
And usually get some really great questions. I just so much enjoy the question and answer period because it lets me know what's on your mind, what's people's mind. Because like I said, one person will ask a question, I'll look around the room and I'll see 10 of their heads just shaking like, yep. And I have that question too. That's just the way it is. Everybody's struggling with the same misinformation that's out there or the mainstream, how this stuff works. And if it's not correct, we need to fix that. So anyway, give me a call at my office at Pierchoski Estate Law, Pierchoski Elder Law. The girls will put you on the RSVP list. And again, it's just a head count thing. Call me at 931-363-7222. You can also go to my website, Estate Plan Stand. That's Estate Plan Stand, ESTAT, planstand.com, and you can sign up from there. And again, if you're thinking, I really want to go, but I don't know if I can commit, and it comes around 9 o'clock tomorrow, and it's like, yeah, okay, we can go to that. Just come on and walk in. We got plenty of room. It's not that formal of a registration. It's not even a registration process. I do it for two reasons. One, so at the last minute, I don't have to pull out tables and chairs.
It's not hard to find either. It's on the square.
Oh, it's a big old building. It's the theater. You can't miss it. And I went the RSVP, like I say, for two reasons. One, I don't want to have to be scrambling with tables and chairs at the last minute. And two, some of the gals that make refreshments, it's like the cardinal sin to run out of refreshments when you're having a get together, right?
Yeah.
So falling short is like not an option. So that head count helps them know what to do, and they always do twice as much anyway, which always ends up around my waistline. So, but give us a call at 931-363-7222, and if you have any questions about anything, by all means. The next one we're doing, I forget the date, but it's going to be in August. It's going to be up in Franklin because we go to quite a few counties when we do these seminars. As you know, we do them sometimes here at the WLX radio station, which is another great venue. And so we're, again, tomorrow, Saturday the 29th, 10 o'clock at the Star Theater on the Square in Pulaski. Call me and get on the RSVP list, or call me and talk about anything that we talk about on this show or anything estate planning. I always say doing nothing can give a predictable result. So
That's right.
I like doing this show here on the WDXE. I hope people that listen enjoy it as much as I enjoy doing it because it is fun.
Well, it's always informative. I always end up with the questions myself, so it's very good. And of course, we encourage your calls when Stan is here, and I'm sure they're going to come at some point. People's going to get ready to ask those questions.
Oh yeah,
but always a pleasure to have you. Estate Plan Stan, Bulletproof Estate Planning, the show, and of course, Pierchoski Law in Pulaski, Tennessee. That phone number 363-7222. And you're doing another radio show too at another station.
This one every Friday from 8 to 9. I do 99.1 out of Nashville, WTN, Super Talk.
Yeah.
I do that every Sunday night from 8 to 9. I've been doing that for over 2 years.
Yeah.
I do one out of Columbia, WKOM. And I think that's Saturday night.
You're a
at
busy
7 o'clock.
man.
That one's pre-recorded, so you can't call in with questions on that one. They don't do it. They don't do it live like this.
Well, brother, we'll see you next Friday.
We certainly will. Thank you, Jeff. It's
God
always
bless.
a pleasure.
Thank you, man.
This is WDXE, W287AA, and W230.